Good evening, everyone. My name's Ben Gioretta. I'm the chair of the London branch of the Chartered Institute of Arbitrators. Welcome to tonight's event. And I'd say thank you to Pennington's for hosting us tonight. I'm standing in at the moment for Tope Adeyemi, who's the member of the London branch committee who has organised tonight's event. She somehow found herself in Cardiff tonight, as we do. So I've been drafted in at the very last minute. I hope people online can still see me. And tonight's event is about cryptocurrencies, and I'll just read out the event. The cryptocurrencies litigation against arbitration. And I thought I'd just mention what Sir Geoffrey Ross, the Master of the Rolls, said about cryptocurrencies. He said, "I believe that three major developments are imminent. They will mean that every lawyer will require familiarity with the blockchain, smart legal contracts, and crypto assets, both conceptually and functionally. These developments are, first, the launch of central bank digital currencies that will put crypto assets into mainstream use. Secondly, the widespread adoption of digital transferable documentation. And thirdly, the transition from analog programs such as Word to smart machine readable documents." And he said that in the introduction to the launch of the new guide from the Law Society into cryptocurrency. So I think it's a very timely event, this event tonight, to talk about cryptocurrencies and the best forum for dispute resolution for cryptocurrency disputes. And tonight we're honoured to have as our moderator Lord Mance. Now, Lord Mance is someone for which, as they often say, needs no introduction. But I should just say, at least as far as his clerk is concerned, that he's now at 7 King's Bench Walk. I'm sure that his chambers like that little plug. He's, of course, had some very unimportant job earlier in his career. He was deputy president of something or other. But of course, you can look him up online if you like. I think he's the only member of the panel tonight who has his own Wikipedia page. As well as Lord Mance, we have Chloe Bell, who is a barrister at Outer Temple Chambers. I should say also thank you to Outer Temple Chambers for helping to organise tonight's event. And she was, as it says here, in a former life, a judicial assistant to Lord Mance. So she's someone who knows Lord Mance very well. And she's ranked as a leading barrister now in cryptocurrency law in Chambers and Partners 2022, which is the first ever cryptocurrency section of that dictionary. Stephen Doherty is a barrister also from Outer Temple Chambers, practicing in arbitration and litigation, working focused on commercial disputes, particularly in the Middle East, and he's been involved in a number of fraud cases and inter-applications, sport arbitrations. Jack Holdner is an associate of Writing Cases Dispute Resolution Group based in London, a dual qualifier both in England and in New York. And he has actively participated in blockchain and cryptocurrency matters, representing fintech in a shareholders dispute and various other cryptocurrency disputes. And on my right here, Charlotte Hill, so again, is perhaps someone who needs no introduction. She's an experienced disputes practitioner here at Pennington's Manchester People, advising a broad range of complex, high-value, multi-jurisdictional disputes relating to financial services, and she has specialist expertise in digital assets, and she advises about cryptocurrencies and blockchain disputes. So welcome to you all, and we're very much looking forward to tonight's event. I'll hand over now to Lord Mance.
Well, thank you very much indeed. That's very kind introduction as far as I'm concerned, and certainly merited as regards my fellow colleagues, and certainly merited as regards my former judicial assistant, who I gather has devised the problem which we're considering this evening. Originally, my brief included the requirement to explain or to touch on, summarize, not merely the facts, but also some of the idiosyncrasies of crypto assets. I think the idiosyncrasies will probably appear quite sufficiently from the problem, and don't need huge elaboration. Obviously, there is a question as to their categorization, the balance of authority. We rather ducked that in a case in the Singapore Court of Appeal in which I sat. We rather ducked the question whether they were cryptocurrencies were property. But I think since then, both in Australia and in the UK, the view has come to be expressed, at least at first instance, that they are a form of property, so they can be pursued as such, so they can be held as such. I don't know whether the contrary is going to be argued by my fellow panelists this evening. We may hear. But there's a further question which may or may not be important in some specialist areas as to whether they are actually a currency, whether they're actually money. Lord Mansfield gave a famous definition of money as something which, by the general consent of mankind, was given the credit and currency of money to all intents and purposes. Well, for my part, I'm afraid to say I have to confess that I wouldn't give any credit to a cryptocurrency, so that in my book, it would be an extremely, although historically perhaps very profitable investment, it would be one which I would not welcome my investment manager undertaking on my behalf. But maybe there are more people who are more bold than I am. The problem we had in Singapore was actually a rather different contractual problem, and I think a very interesting one, because it combined the issues relating to the nature of cryptocurrencies with the concept of smart contracts. Some of you may know the case, and we're not talking about it really very much this evening, but it's probably one of the more amusing cases one has ever done. It involved a contract. Does anyone know it? Does everyone know it? I won't bore you if you do. It involved a contract made in the middle of the night between two computers. And because one of them had, by computing state, being cut off from the world markets, it thought that there was no market except an offer which the other had been programmed randomly to put out at 1/250th of the real price. Now, in normal circumstances, an offer at 1/250th of the real market price would be ignored, and no doubt it never previously been accepted. But Joy, this other computer, which thought there was no market, thought it was actually realizing the crypto asset which it held in order to fill a margin gap. Anyway, it thought it had to take this one offer, and so it sold Bitcoin at 1/250th of the value in return for Ethereum. When the lucky owner of the fortunate computer woke up in the morning and saw the computer printout, he immediately sent a message to the platform saying, major computer breakdown. And I thought that was rather significant, and indicated that this contract couldn't stand because he can't have really thought that there was any intention to contract. But the majority said, no, there was a contention to contract. You delegated your intention to the computers, and when they contracted in the middle of the night, they didn't know anything about a mistake, and they made a contract. And so the majority finding was there was the contract which couldn't be set aside on the grounds of knowledge of a mistake. Anyway, that's probably a deviation from this evening's interesting fact pattern, which is a rather different one. It involves a scheme whereby for the purposes of enabling easier trading, owners of cryptocurrencies are able to exchange them on a one-to-one basis with Flexi tokens, FT tokens, issued by a firm called Flexi tokens. That's a wonderful scheme so long as it continues to work. And it was a scheme which was underwritten by you can, of course, then redeem them back. If you want to get back your Ethereum, you give for one Flexi token and get it back. But that sort of exchange was only guaranteed by the firm Flexi tokens itself. It may be that the tokens had some value on the open market, but the only person who, under this scheme, could redeem them was Flexi tokens. and as we shall see, something went wrong. What went wrong was that Flexi Tokens was itself hacked, and the hackers took all the real Bitcoin, or at least 1,200 real Bitcoin from Flexi Tokens reserves, and that quantity of Bitcoin happened to include 10 Bitcoin, which Mr. Javier, who is the claimant, had given to Flexi Tokens in return for 10 FT tokens. And when the hacking was discovered, Flexi Tokens wrote to all current account holders of tokens, stating the redemption of the tokens was suspended until further notice, and it hasn't been recommenced to this date. The question is, what happens? Not surprisingly, Mr. Javier wants to get wants his 10 tokens to mean something, and he's anxious. He's been ingenious enough to hire an expert to trace the original 10 Bitcoin, which he gave to Flexi Tokens, and see what's happened to them after the hack. And tracing shows that 4 of them are still in Flexi Tokens reserves, so they weren't all taken. The remainder are in a number of wallets in different jurisdictions around the globe. So there are 4 suspended in Flexi Tokens reserves. I think I have to correct something. Impression I gave earlier that all 10 had been hacked. The 6 which were hacked are all around the world, for example, in Singapore, China, Russia, and Canada. And it's unknown whether those wallets are held at exchanges or are private wallets. And Mr. Javier is seeking advice as to his options. What can he do? How can he get his tokens back from Flexi Tokens and or from the present holders around the world? And he has an understandable and commendable preference to deal with the matter in the UK. He has no connection with some of the jurisdictions which might otherwise be relevant. And other jurisdiction might be relevant for this reason, that Flexi Tokens trade on conditions. And the conditions of service, which are set out in some detail in the handout you've got, are, well, clear, possibly capable of being described as bone crushing. They effectively say that, in very clear terms, that arbitration is the sole means of recourse you have in the event of any dispute arising from the use of Flexi Token services. You must attempt first informal resolution before any demand for arbitration. But if you get to arbitration, then any arbitration will occur in San Francisco, California. It will be conducted confidentially by a single arbitrator in accordance with the rules of JAMS. And the state or federal courts in San Francisco, California have exclusive jurisdiction over any appeals of an arbitration award and over any suit between the parties which is not within the arbitration clause. And the arbitrator has authority to grant any remedy otherwise available in court. Any dispute will be governed by these terms and the laws of the state of California and applicable US law, without not the conflicts of laws principles, and etc. So there you have the problem. One might just add as a sort of hint as to what is going to, some of the argument which is going to come, that Mr. Javier may perhaps have a status as a consumer, but we'll hear whether that is relevant. He is a UK national and resident, and he opens his account with Flexi Tokens, who are incorporated in the Seychelles, so that there's a mix of laws, and I'm sure you're going to hear some submissions on what the governing law is and whether English law is applicable to that extent. So who is going to open the batting and who's going to introduce our speakers?
So I think Charlotte and I are going to start off because we've assigned ourselves the title of legal advisors to Mr. Javier. And we did start from the premise that Mr. Javier is a consumer, which is significant because under Section 89 of the Arbitration Act 1996, Part 2 of the Consumer Rights Act, which deals with unfairness, is applicable regardless of whether or not another law is applicable in the arbitration agreement. So that was our starting point, that we could challenge the enforceability of the requirement to arbitrate because of his status as a consumer, and that we would also say that the compulsion to arbitrate is arguably one of the grey listed clauses in Schedule 2 to the Consumer Rights Act, which essentially presents a series of clauses that may be deemed unfair by a court. Paragraph 20 of Schedule 2 says that a term which has the effect or object of excluding or hindering a consumer's right to take legal action or exercise any other legal remedy, in particular by requiring the consumer to take disputes exclusively to arbitration not covered by legal provisions. So we thought this could very well fall within paragraph 20 of Schedule 2 in the grey list. Query then what an arbitration not covered by legal provisions is, because that seems incredibly broad. After a bit of digging, there's one case called Malchris Builders, which is from the Technology and Construction Court, which essentially tracks the history of that phrase in paragraph 22 European Union law, which essentially was meant to cover statutory obligations to arbitrate. So Mr. Justice Ramsey in that case decided that the Arbitration Act 1996 and proceedings under that act were not arbitrations not covered by legal provisions. So it's actually narrower than it might first appear. I'm going to hand over to Charlotte to continue the rest of our thoughts.
Thank you. So just continuing on the same vein, the Consumer Rights Act, we sort of counted through it, trying to work out how else we, on the sort of acting with Mr. Xavier, wanting to avoid the arbitration clause, making him go to arbitrate via JAMS in California, trying to work out how else we could persuade the court that he satisfies as a consumer, in which we can then say the arbitration clause is unfair. So just a couple of other points, which I'm sure most of you would have picked up on in either reading the case study or hearing Lord Mance's very helpful summary. Firstly, of course, he's an individual based in the UK. He is said to be both national and resident. And therefore, under the Consumer Rights Act, he's treated as a consumer for the purpose of this test. We want it to fall within English law because, as Lord Mance helpfully said, under English law, it has been said at first instance only, and in most judgments which have not yet been, or at the time of judgment that weren't challenged, they were unopposed, crypto assets and cryptocurrencies are deemed as property. And so for that reason alone, while there are other jurisdictions that have either followed suit or have adopted a similar premise, from our purposes, we think that's most helpful. And so we've carried on in the same vein to work out quite how else we can establish that he's a consumer and that the clause is unfair. We debated, and actually I don't think we've settled necessarily on an answer to this, but whether it's the crypto assets as a good under the Consumer Rights Act, or whether, and perhaps you might both touch on this in a minute, leading you in, but whether it's digital content or whether perhaps it's something else. And to my knowledge, I don't think there's any judgment yet which has confirmed either way as to where that would fall. And so no doubt that's going to be rife in future battle. I think that probably takes us to where we've satisfied ourselves and our advice to our client that we would say he's a consumer, and therefore we think we can challenge the arbitration clause, make them enforceable, and we'll move on, I think, once we perhaps have your response as to why we think English laws would suit in this occasion.
Well, thank you for that. Good start. I'm briefly, well, first, thanks for also having me here. And then I think we will briefly touch on some preliminary points. One would be us talking, just also thinking what company like Flexi Token, what are their strategies, what are they trying to achieve? And I think Stephen will address some of the more specific points regarding here, the arbitration and the Consumer Act points. But I think from FlexiCoin, what's important here is that they do a very specific type of cryptocurrency project, which is quite similar to the stable coins. I assume are most people familiar with stable coins? in the room? No. Well, so the idea of a stable coin, which type of cryptocurrency, is that the price of it is linked to another asset. Most popular ones are US dollars. So Tether and USD coin, for example. So the price of that coin is always set to whatever the dollar is. So in this case, whereas we have other tokens that the price is set by the market. So that's why, Bitcoin, Ethereum, why the price is multiplied, I don't know how many times. But in this case, the Flexi token, its value is set to the Bitcoin. So in a way, its value, maybe you could argue, it doesn't necessarily depend how the project is doing, as it's always tracking Bitcoin. But the key issue here is for stablecoin projects is that what they usually promise is that there is a reserve of the underlying asset to which it's tracked. So for companies that track the dollar stablecoin, they say we hold in our reserves sufficient assets in actual dollars somewhere put away. So in this case, it's a really important fact that for the business plan of Flexi token, they must be holding somewhere actual number of Bitcoin or Ethereum, which allows them to offer their tokens. So with that sort of a part, I think in mind, when, let's say, we have this dispute, I think a really key point here is what we would want to do arbitration is to keep the public, first of all, from knowing maybe that there has been a hack. I think it's a pretty big problem if it turns out that, well, we don't know exactly what % of these Bitcoins were taken, but if this is a big portion of the reserves, I think you could undermine the whole public trust in the project and in the token itself. So, and these are one of the key points why I think, the arbitration here is good. We're talking confidentiality, it's private. You get to control a lot more of the process. And particularly in light of this project, I think from the Flexi tokens point of view, you really want to focus and do your best so you don't go through an open sort of court proceeding. So that's one sort of key point here. The others are, somewhat typical, where you want to avoid, opening the gates, inviting more arbitrations, more litigation. And I think, again, not having the news out there of going a case through the courts will be positive. I think this is one of the main strategic points I wanted to address. I think Stephen will now briefly talk about the more specific legal issues.
Yeah, I mean, I just kind of touching off on arbitration again, and why that is probably an attractive strategy to someone in the exchange's position is, well, I suppose first of all, it's been touched on by Chloe and Charlotte. There's probably going to be a degree to which the most advantageous approach is going to be the one that the counterparty to your potential claim doesn't want to happen. There is an advantage to the exchange of playing at home or playing by the chosen jurisdiction's rules that were set out in the arbitration agreement. I think in this case as well, and I know the speed of an arbitration is probably a subject of how its parties wanted to progress. If they wanted to go quickly, it can go quickly. In practice, I'm sure a lot of us know more often than not, arbitration can be quite slow. And there can be some strategic advantage of that in this case, where we have what is 1,600 Bitcoin at large. It might be that a strategy of trying to prolong and delay things is actually allowing some more time to try and recover what's been lost, stabilize the company's position. And I think another point for the exchanges and why arbitration is an attractive proposition is going to be trying to place limits on group litigation or on class actions. It's probably going to be an increasingly popular way of dealing with these sorts of disputes. A lot of them are not particularly high value. But obviously, when you clump that all together, if you've got the risk of negative authorities and so on, if you can nip that, but obviously that would be something that you'd want to do. In terms of the strategy for actually answering this claim, so we've had notice, say, of a potential claim coming in to the English courts. I think there are probably three considerations from the exchange's point of view. The first is whether and to what extent you engage the English case. The second consideration is what are we going to do to try and engage these proceedings elsewhere. And then there's a third, slightly separate issue of what's going to happen with the Bitcoin. And I'll address the first two of those, and I think Jack might be able to pick up a bit later on the others. The first is whether we're going to accept using the English courts as the first foray into this. And one of the things when we discussed this, it seemed immediately an obvious option would be going straight to the courts of California and trying to get either an anti-suit injunction or combine that with a motion to compel arbitration. And there seem to be quite a few pros of that approach. The US is a jurisdiction where consumer arbitration is much more common. It's quite permissive, and it's built into its Federal Arbitration Act that you have effectively a presumption in favor of arbitrability. That would sidestep some of the issues that you might have to deal with in the English courts with consumers. Potential cons are, I suppose, the issues that might arise with that. If you looked at the construction of this arbitration clause, for example, one of the reasons the US courts, including the courts of California, have decided that some disputes aren't arbitrable depend on the construction of what's entailed within that particular dispute. So if you've got a clause which say that any disputes arising under this contract can be referred to arbitration, sometimes the courts can interpret that narrowly as being, well, it has to be a dispute which is about a breach of the contract, or it's some issue relating to the interpretation of its terms. That's distinct from, say, disputes relating to or arising from the contract, which is obviously much wider. I think in this case, we've probably got somewhere in the middle. Let's see if I can get the arbitration clause up. Yeah, so here we're talking about any dispute arising under these terms or your use of the services. You might think that that's a point that could go either way. So potential area of risk. The other thing that the US courts have looked at is there proper notice of the clause given to the consumer? So, and often that's fact sensitive. You know, how did you tick through to sign off your agreement to the user agreement? How was attention drawn to the arbitration clause? And I suppose in this case, what you'd point towards is the pretty big block capitals at the top of the page saying, read this carefully because it limits your access to the courts and it prevents you from suing in court. And again, I think that would probably be something we'd push in our favor. The other problem with that, though, is it's time consuming potentially to go before the US courts. It might be something that is expensive as well in the context of a dispute that's not necessarily that big. So you might take a view that you've got a better course of action in challenging the English proceedings. So this consumer issue, the question of arbitrability. As Chloe said, the consumer rights legislation places arbitration clauses on a grey list. But I think probably that's a fairly neutral point. The very fact that it's on a grey list means that if you're saying, you know, you can't have a consumer arbitration, it would make that somewhat illusory. And in fact, there are probably two sources of authority, I would say, in this case, why you would say that this is a case which is arbitrable and actually suitable for arbitration. One is the choice of the Arbitral Institute, JAMS, takes into account thresholds. So if you've got a case that's above $250,000, there's a certain set of rules, and then lower value cases have a more streamlined procedure. So there's obviously a value link there. The other point I think that the exchange would take in support of its case is that the Arbitration Act in the UK, again, places a connection on value. So any dispute under £5,000 automatically is unfair. We're not really talking about something that's in that ballpark. In this case, we're talking about 10 tokens, which is 10 Bitcoin, which when I looked earlier was about $400,000. It might have doubled or halved since then, I'm not sure. But the point is that there's clearly a value link. There's going to be a point at which there's a line. And I think in this case, where you're looking at a dispute running into a couple of $100,000, you might say that this is perfectly well suited to arbitration.
Can I make one more? So one legal challenge for me to the other side. It was just, so we're assuming, I think in this case, there would be service outside of jurisdiction, right? But
Yeah.
I think for Flexi tokens, we would definitely avoid any local presence. So in that case, I think, and there's a lot of good cases, or even done by Chloe. I was reading on the cases. She's on the on the paper, but the analysis likely then would be about the gateways. And I think it's the main sort of reasoning so far in the case law has been very strongly attaching to one case that says that the lex situs for the cryptocurrency is essentially the owner's location. So essentially, then a lot of the gateways sort of open up. Where's the harm suffered? Well, it's where I lost my property. Where my proprietary rights is where where the Bitcoin that was stolen was located, and so forth. But I think that's I'm not so sure that that's fixed in stone for the future. That reasoning, because really, when you think about it, the Bitcoin isn't the only place where it really is. It's on the ledger, right? It's somewhere on the chain, and then it's in the nodes that are spread all over the world in the computers. That's sort of the reality. And I think there might be some more interesting analysis if we knew, for example, whether the exchange is holding the person's private key and controlling that token, or whether they're just acting in a decentralized manner. But I think so far the cases have held that really, where you're located and you own Bitcoin, that's the location, that's the legal issue. I think that makes the gateways a lot easier, but I'm not so sure I would challenge that in the future if I was on this side of the table. I think there was just one more point, which was, where the contract is made in this case. We don't know if there's email communications, how the system was set up, but you could argue, right, that the offer was accepted when it was sent back to the US. So I would put up a fight here also for the point that, that there is no jurisdiction. And I'll give it back to you.
Yeah, so just as a point of interest, there's a case that's being lodged in the Queen's Bench Division called Amir Soleimani and Nifty Gateway LLC, which is about NFTs. And it contains a very similar arbitration clause to the one that appears in our problem. And that is being challenged. Its enforceability is being challenged in that case. So do keep an eye out for future argument and judgment in that case, because I think that will give some guidance on how the Arbitration Act and the consumer provisions under the 2015 Act are actually going to play out in practice. And on jurisdiction, Charlotte,
Yeah, so the other just 2 points that if you can get it under the Consumer Rights Act will be super helpful in this instance. There's two sections, 32 and 74 of the Act, where in short, I won't quote it, but if you can establish then the law of a country or territory other than the UK is chosen by the parties, as it is here, California, but the sales contract has a close connection with the UK, as it is here because our individual is based in the UK, in which case then you can then disapply, or subject to certain exceptions, you can then disapply the choice of law under that clause. And therefore, of course, from our position, we would try and cut down the California law to bring it in to English law. And the other point, just I think to respond to you, Jack, I think that's a really good point about the jurisdiction. I mean, typically when you look at the cases in first instance at the moment, they are, as I was saying earlier, they're unopposed. And so, service out hasn't really been a problem. They've got through the gateways and permission's been granted. And on this occasion, we'll come on to in a minute when we litigate why we want to litigate rather than arbitrate on behalf of the individual victim. But usually speaking, that will be because you need your urgent freezer or injunctive relief. And so for that reason, you, the exchange or whomever it is, isn't going to know about it. And so by that point, then we've already moved on. And obviously, as and when you start to engage, unless you're suddenly challenging jurisdiction, it's too late. So I think that will be an interesting development if and when you get some cases that are brought on notice that are dealt with in the ordinary way.
Just in the interest of informed debate, be careful about the current gateways, because obviously you're very familiar with them, but there is a possibility that they may be expanded, and some of the phrases may change. Familiar phrases like "in respect of" may be changed. I'm not saying they will be, but there is something just to watch out for in coming months. Can I just ask another point? But you've been focusing, I think, all of you so far on claims which would fall within the arbitration clause, which is confined to disputes between the customer and us. That's Flexi tokens. You and Flexi tokens agree to arbitration. So that's fair enough. 4 Bitcoins are still with Flexi tokens, and they can be potentially held responsible for having lost the others through the hack. But we also know where some of the Bitcoins are. Can I inquire? I mean, is there a possibility that they might be a claim which Mr. Javier has outside the scope of the arbitration clause? Perhaps this is not the subject matter really of this evening, but
no, it's kind of one point that Charlotte and I were then going to kind of bring in terms of the strategic benefit of being able to litigate, because that way you can bring in third party or Part 20 defendants, or seek third party orders such as freezing injunctions against the fraudsters or proprietary injunctions against the fraudsters, to seek proprietary remedies against them.
This would be based on the proposition, would it be, that although he swapped his 10 Bitcoins for 10 tokens, what the 10 Bitcoins are nonetheless in reality, those specific Bitcoins, that blockchain held him on trust?
Yes. Yeah. Which is what you dodged in the Singapore.
Yeah. Very wise. It was quite enough issues.
I mean, if we can, that was actually exactly the next point sort of we wanted to address. I think very smoothly done. It is interesting because sort of my reading of the case is that likely you have to start analyzing the proprietary interest in those Bitcoins. And I think when based on the facts as they look, I think that all that Mr. Xavier owns, he owns the Flexi tokens. He doesn't own those Bitcoins anymore. And I think actually there's an interesting recent cases at Wang v. Darby, right? So essentially where we had one person send 200 of Tezos coins to be used for mining, creating more Tezos coin in return of Bitcoin. And then the agreement was, later in 2 years after you've used these coins, so what they called, I think, baking with Tezos, I get back more of these, I'll give you back your Bitcoins or whatever the relevant number is. And what happened in that case is that Mr. Darby just said, well, he just sold those Tezos and said, well, I'm not baking, I'm not giving them back to you because the price of Tezos has gone up a lot. And then, so Mr. Wang wanted essentially to force and to get back his the Tezos, but the court said, well, you essentially, there was no trust. You exchanged them. You gave up any right in those Tezos that he then sold. Of course, there might be other claims, but I think in this case it would be quite similar, where you have the Flexi tokens, and of course, if they're valueless, there's other claims. But I think Stephen also had an idea here. Then was that your first point, to try to prevent actually these type of injunctions? Yeah,
I suspect that probably strategically from the exchanges perspective, there's going to be a bit of a bun fight over who gets to claim some proprietary interests. So Mr. Javier has lost, we would say, potentially the value of his Flexi tokens, but he's exchanged his Bitcoin for those originally, so his proprietary interest remains in the Flexi tokens, and that ultimately it's the 1,600 that have been misappropriated, which the exchange is going to have vested interest in trying to get back to try and stabilize its own position. So I think there's potentially quite a lot for the exchange to think about in terms of, if it's going to pursue some form of anti-suit injunction to try and effectively prevent the individual from stymieing their own ability to get freezing injunctions over these assets and to try and trace them and to try and ultimately get them back.
Yeah, I think we would argue that the value of the Flexi tokens is derived wholly from the asset that they're pegged to, which is a Bitcoin, and that in some ways the Flexi tokens are a bit like tokens in a casino, that you put your cash behind the desk and get tokens to use in the casino, but the value of the tokens is connected to the cash. So I think we would argue that actually we never handed over the beneficial entitlement to the underlying assets, and it looks a bit more like bailment, and we bailed, albeit it's not available for intangible assets at this point in time, but we bailed the Bitcoin to you for these tokens that we can exchange more freely.
Yeah, I saw it as kind of the staking process, which I know that hasn't yet sort of been litigated on, but the staking process is that you essentially contribute your underlying crypto, say on this occasion Bitcoin, it's then almost treated like an interest-bearing savings account. So then actually it goes out to work for you, and then the other miners will then put proof of staking on, and for that you get your reward back, which is almost like your interest. And so on that occasion, really, these Flexi tokens are like your interest on the Bitcoin you've contributed. And as a result, I would see that as you say, beneficial ownership hasn't yet been transferred over. And as such, we would then claim that we get the value of the Bitcoin, which of course, on this occasion, are much more valuable than the Flexi token.
Questions at some point? Yes. What about opening it up to the audience to raise any questions or points? Yes.
Actually, 2 points. One on the immediate point you had, because it says you can redeem it at either Flexi points at any time. So it is absolutely, that's what I think. Okay, just sorry, give it back to me now. So that would support, I think, your argument. The other thing is, of course, a hack has to be reported regardless, and whether it's in the States or in the UK. So to keep it quiet is, I think, pretty slim.
Yeah.
So that's the other.
Well, thank
thing
you.
I thought.
As it didn't seem an immediately positive message in favor of arbitration. Enables you to hide things which have gone wrong.
Yeah.
Obviously, the argument nevertheless for arbitration would be that if you use the details wouldn't come out.
Yeah.
And also the owner would be protected, that nobody knows how many Flexi tokens Mr. Javier actually had, and how many sort of the individuals would be protected by arbitration.
And
would be protected by
if I may, in my defense now, I would just say, I think it's also big issue is the disclosure process, and those, because of the project that it's involved in. I think now, when you look at in the US, there are the big litigations against Tether and the companies behind it, I think, where all of that is sort of, it's being addressed. So that's kind of what I was, I was trying to be more colorful to bring some, light in the evening.
I think it really does depend, of course, as it does with most disputes, which side you're acting on. You see many exchanges, we act both for and against, where they will understandably try and put the arbitral clauses in, simply because A, they need the confidentiality because they want to avoid the class actions, which is becoming much more common around this area. And then B, also because they want to, as you were saying earlier, slow it down. Typically speaking, when you go down the arbitral process, you need to, it takes time to constitute the tribunal. Even if you get your emergency arbitrator up and running, it takes a couple of days. These are all arguments you all in this room are familiar with. You don't need to rehearse them, but conversely for the consumer particularly, and they do tend to be, again, as Jaak and Stephen were saying earlier, tend to be relatively insignificant amounts per investor. For an individual investor, no doubt that's a lot of money, but actually when you're going up against such a large powerhouse, an exchange that is intentionally structured that they're in the Seychelles or wherever they are, is costly, it's complex, and it's just something that more often than not is disproportionate for them, unless you can get something like a class action off the ground. And so for that reason, you typically see the consumers are pressing, understandably, for A, English law, and B, litigation. And you typically see the exchanges and the other companies sort of dealing in that crypto side to want to, of course, set up the arbitral process.
Any more questions?
That's another point about arbitration, which is the opposite of the traditional justification for arbitration, which is informality and speed. And I haven't come across it expressed quite so overtly before.
Mic'd him for my client today, so.
No, but it's interesting. It seemed to be a generally accepted point.
I think the other point as well is when you seek the injunctive relief, typically speaking, and I'm talking very generically here, via litigation, you would go, of course, ex parte, whereas via the arbitral route, typically you still need to be given the notice, depending on which rules you're under. And so again, that's another reason, because typically you need to seek to freeze the asset. If you finally manage to trace it and find the wallet and which exchange or whoever's holding it, then actually all you need is time of the essence and quickly run down to court and freeze it. Because otherwise, because crypto is so intangible, it could be in a completely different wallet with a completely different key in 3 seconds flat. And so for that reason, I think from a consumer victim side, I think litigation really lends itself as well.
although I suppose a word in favour of arbitration in terms of actually increasing speed for the resolution. Going forward, it might well be that you can use arbitration as a mechanism to build in a smart contract or provide some form of on-chain enforcement, which deals with what actually is potentially the really difficult bit of these sorts of cases, which is, all right, well, I've won my case, I've beaten the other side, but how am I actually going to get anything out of this? How am I going to get my asset back? And if you can empower your arbitrator to effectively hold, let's say, the asset's still there for you and then decide which way it goes at the end, that potentially cuts quite a lot of time, cost, difficulty out of disputes.
Yes, question here.
It's me being stupid, probably, but I'm not sure I see the argument that the two ladies are making, that the gentleman, Mr. Javier, still owns the Bitcoin, because the point of the story was that the tokens were transferable. And so it so happens, presumably, that he hasn't transferred it. But there never can be an intention that the individual Bitcoin be held in trust for him.
Could be
It have to be held in trust for whoever owns the tokens, which seems to be a much more difficult item.
Yes, I think that is a good point. But I think ultimately the person who has the token has a right to have it redeemed at any point. Their right to the underlying property.
Yeah, I mean, I'm just thinking, because I like legal history, that you might want to go back to when banking starts and you put your money with a goldsmith. And presumably there were the same arguments before the courts in the 17th century, to which the answer given was that it's not property, it's only a claim in debt against the bank.
Yeah, and I think that question is going to come up in litigation in terms of how exchanges hold crypto assets on behalf of their wallet holders, because in many ways they do operate like banks, because they take the assets deposited in their wallets and use them for their own purposes. So I think that question still has to be addressed by the courts.
Do you want to take some questions from the webinar?
Yes, eyes.
Oh, I don't know.
Right, so sorry.
We've not been
Just
paying
steal a
sufficient
Bitcoin.
attention. How do you feel
It's asking for a friend.
Yes, Stephen, you give the answer to that.
If I knew, I might not be here. I don't know.
I mean, I can.
Yeah.
Yes,
Of
John.
course, I'm playing the evil person. No, but essentially the key aspect is, which is also part of the proprietary rights analysis, is the control of the private key. So usually it depends on whoever has control of the private key controls the spending of the Bitcoin, because I mean it's not really like you're ever holding it. It's just that it's on a ledger, and by having the private key and stamping the transaction, you get to spend the coin. So in a way, you're never, you can never really like grab it and hold it. What you can do, the stealing, so to speak, will be that you send it, the ownership of it in the ledger, which is recorded on the blockchain, to an address then that is yours. So I suppose that maybe that's as close as you get to stealing.
Yeah, and the other ones that typically come about where there'll be some sort of Trojan horse or something sent through an email link. So actually then they're watching your keystrokes, and then you enter your private key, which is more secure if you hold it in a cold wallet. It's offline. So you have it, literally some people have written down in analog, saved away somewhere, or in separate sort of USBs, different devices you can have to store them offline or online, but online is much easier to hack. And then somebody will be watching your computer, see you type in your private wallet, and then suddenly, as soon as you log off, then they'll go in separately into your account, use your private key, and then out it goes. Going back though, just very briefly, if I may, just before I forget, one point we're talking about the arbitral clause and the way you might be able to build in the work of a smart contract. That, I think, from my understanding, has been brought up to an extent in the digital dispute resolution rules, where one of the suggestions there is you of course appoint an arbitrator who's an expert in this field, which is a massive incentive for arbitration, but then B, and this is where I'm not sure if this would work in practice, but the parties agree to hand over their private key to the arbitrator, almost to hold in escrow, so then they can then resolve the dispute, and then they can actually then enforce it on chain. Or quite, and also if you as the victim or you as the holder of the private key wants to also hand that and give that over to somebody else, because there's one thing having an order and there's another thing actually enforcing it or satisfying it. But yeah, so there's concepts about that. But.
And I mean, oh, there's questions.
Shall we have one more question? This is someone who's throwing several googlies to the panel, basically about, well, apparently the Canadian government has just issued terrorist sanctions against certain crypto asset wallets associated with those of the Canadian trucker protests. But leaving aside the Canadian aspect. So the question is, how does one sanction a wallet, especially if not held in an exchange? Much of the case we've been discussing today assumes an exchange. High value holders don't hold an exchange, they're held privately. How does one sanction a non-person? Given to my knowledge, sanctions have been person or country based. How does an arbitrator or an arbitration advocate handle, if at all, a sanctioned wallet? Is there any duty in that respect? Does the sanction continue on the blockchain? Does it affect transferees, in other words? Well, who's going to attempt those?
So I actually did a freezing case, which did involve private wallets. So you can get them, but the reason why it was valuable in my case was because it was a stable coin, which had a centralized entity that could freeze the stable coin from the central location. So, but I think if you had a traditional cryptocurrency like Bitcoin, it would be pretty valueless to have a freezer over a private wallet, because it just wouldn't have any effect. But it is valuable if you've got a stable coin, and the minter of the coin can actually freeze, destroy, and remint the coins.
But ultimately, I think if they're held in the private wallet, they almost lose their value, don't they? Unless they suddenly then want to do something with it. So I think you would then want to trace it and keep a track of it, because you assume one day they want to do something with it. And then when it then goes back into an exchange or something, at that point, you would then try and freeze it. But
I think
when they do that, who knows?
Yeah, I think you can get investigators to put a watch on the wallet to see when it moves. And then at that point, you can go and get injunctive relief.
Well, that has obviously answered the googlies. Any more questions? Yes. Oh, there's another googly. Everyone is yes, and everyone is assuming a crypto is held in an exchange. Big ticket items aren't. Well, how would the answers change if no exchange is involved? I think to some extent just covered that. Then surely when exchanging a Bitcoin with a token, then the Bitcoin holder transferred the ownership of the Bitcoin to the token company. Again, I think we've really touched on that and probably answered it. So there's a debate as to whether you retain a beneficial interest in those particular Bitcoins, or whether this is an out and out transfer, a swap. Again, I would have thought that might be something that depended rather on the terms of business. I think you could probably structure it either way. Token, this represents you'll have the right to have your Bitcoin back. They're effectively held, if they are property, as the authorities suggest, for you.
And I think in the New Zealand High Court decision, the use of the term custody in the terms of service in that case was quite significant in terms of their decision that it was held on trust, and that the kind of language that was used in the terms of service was deemed to be significant.
I think in the recent Wang Darby case mentioned that the court did say that even though in that case a trust did not come about, they said a trust can under the certain circumstance, and exactly like you mentioned for staking. So usually saying, if it's sort of agreeing the terms that the interest, sort of the loan, depending how you structure it, the agreements. And I think also depending on how for example, the private keys are held, who gets to actually press the button, because in a lot of the exchanges, you could either have a decentralized exchange, essentially, where the person is always holding their own private key, but only essentially the technology of the exchange helps to sell it. They find somebody to sell to, but you're holding on to your own private key, versus the ones, custodial exchanges, you actually give your private key to the to whatever normal company on the server, and they just control it to transact on your behalf. So I think it will be very much a factual analysis on sort of the terms of the holding or staking, and then the actual reality of holding the private key.
Well, thank you very much. And that was a fascinating discussion. And I must say, this discussion has really shown up the immense knowledge of all the speakers on the panel. I've learned quite a lot tonight, and certainly a lot of the terms I'd never come across. I didn't know what a cold wallet was, for example. And I think also the fact that your level of knowledge is demonstrated by the fact that you very ably and eloquently identified what you don't know and identified all the issues that will be coming in front of courts and arbitrators in years to come, and actually not even years to come, in the very near future, because these are being litigated currently, and there's some fascinating questions and quite fundamental questions that you've identified here today. So can I just invite everyone in a second to express their thanks for tonight, and afterwards could I also invite you to somewhere out there, there are refreshments.
I'm sure we'll walk out the door and I stew will see some refreshments, yeah.
Thank you very much.